15th Amendments. And one of them leads to this Supreme Court case of Plessy versus Ferguson. And let's talk about this case. So Homer Adolph Plessy was 7th, 8th Caucasian, 7th, 8th white. And he's arrested in Louisiana for refusing to leave a railroad car that had been reserved for white persons. The state of Louisiana had a policy of what they referred to as separate but equal accommodations for the white and, quote, colored races. So, to protest this state law, Homer Adolph Plessy gets on the railroad train reserved for white people and is arrested. And again, I said he was 7th, 8th white. I mean, let's think about what that even means. Okay, his parents? No, they're all white. His grandparents? No, they're all white. His great-grandparents? Uh-oh, one of them is African American. Oh my God. So obviously, Louisiana took their discrimination, their racial discrimination, very seriously. So they arrest him. And the question becomes, does the separate but equal law, or doctrine as it was referred to, violate the 14th Amendment Equal Protection Clause? So it goes to the United States Supreme Court, and here's what the Supreme Court says. The object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law. Well, that sounds promising. The only problem is, then they say, but. And whenever you say but, you know you got a problem. So then they say, but in the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality or a commingling of the two races upon terms unsatisfactory to either. Laws permitting and even requiring their separation in places where they are liable to be brought into contact do not imply the inferiority of either race to the other. Really? And have been generally, if not universally, recognized as within the competency of the state legislatures in the exercise of their police power. So the United States Supreme Court is saying that the 14th Amendment must be interpreted as allowing for separate but equal. That's amazing. Now, there was only one dissent, and it was Justice Harlan, and he says, in the view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class. There is no caste here. Our Constitution is colorblind and neither knows or tolerates classes among citizens. In the respect of civil rights, all citizens are equal before the law. But he was the only dissenter. The rest of the United States Supreme Court reject that argument. Say that the 14th Amendment and Equal Protection Clause does not provide some kind of bar to separate but equal based upon race. So think about the legal consequences. As a result of this decision, even after the passage of the 13th, 14th, and 15th Amendment, we enter this era of qualified legal discrimination, which simply means, yeah, you can discriminate on the basis of race, but just use the term separate but equal when you're doing it. As long as you say separate but equal, the Supreme Court will uphold it. So what happens in regard to this decision is that states and localities respond, and they respond with separate bathrooms, separate schools, separate restaurants, separate hotels, separate parks, separate drinking fountains for the next 50 years. These things were called the Black Codes, or Jim Crow laws. So as part of this, we have things like the grandfather clause passed in the South that said you were not allowed to vote unless your grandfather had voted. Well, think about that. If you're a former slave, what was the chance your grandfather voted? 0. And it was upheld by the courts. The court said, well, this has nothing to do with race. We'll deny a white person the right to vote if their grandfather hasn't voted. They implemented literacy tests where they would interview people who wanted to register to vote. And they would ask them questions and saying, if you're not literate, if you can't pass this test, you can't vote. So if the person was a white male, the question would be something like, and I'm just making this up at this point, the supreme law of the land in the United States is the United States Constitution. Very good. You're brilliant. You can vote. And then if you were African American, the question was, please tell us what the 10th Amendment means and how it's been applied. Oh, you don't know? You're obviously not qualified to vote. You can't vote. So throughout the South, these laws come into play, separate but equal. And then they even had to come up with tests to determine whether or not someone was black or not black. And in some states it became as simple as they would put a pencil in your hair and ask you to bend over. If the pencil fell out, you weren't black. If it stayed in your hair, you were, and you could be denied rights. So this is the way it was in the United States from 1860 until the 1940s. Well, in the late 1940s, a new era begins to dawn in the United States. And the United States Supreme Court starts to inch toward a repudiation of the separate but equal doctrine. And there's a series of cases in which this happens. And the cases are brought by the NAACP, National Association for the Advancement of Colored People, who would start challenging this idea of separate but equal. And they challenge it because they said, wait a minute, we just fought World War II. African Americans fought and died in the tens of thousands fighting for the freedom of this country. So why should we be denied the same rights as everybody else? We fought, we bled, we died. And eventually the Supreme Court started changing some of these laws. So you had a situation, for example, of Sweet versus McLaurin, And Herman Sweet, who was an African American, was denied entrance into an all-white Texas law school based upon race. And he said that that was not fair, was a violation of his rights. And by the way, there was no African American law school. So this wasn't separate but equal. It was just separate. And the courts, in reviewing it, said, you know what? He's right. If you're going to say we're doing this because it's separate but equal and we're not admitting you, you at least have to have another facility for African Americans. Same kind of thing happens in Missouri. In that case, we have a situation with Lloyd Gaines. He was a black student who had graduated from Lincoln College, which was an all-black college in Missouri. And he applied to a state law school. And he was denied admission because he was black. When he appealed this, the state of Missouri said, separate but equal. And he said, but there is no separate. Missouri argued, well, we have a policy in the state of Missouri where we will pay the costs of African Americans to go out of state to black law schools in other states. That goes to the Supreme Court, and the Supreme Court said that that approach was unconstitutional, that a state cannot shift its burden, its legal responsibility to other states, that if it wants to assert separate but equal, there has to be separate and equal facilities for white students and African American students. So emboldened by these legal victories, the NAACP says, you know what? We're going to stop taking on separate but equal at the edges, and we're going to take it head on again and say, you know what? Separate but equal is unconstitutional. It's a violation of the 14th Amendment Equal Protection Clause. And that's exactly what they do in the infamous case of Brown versus Board of Education. And that is in your book. And this is a case decided in 1954. And I'll give you the facts of this case. This case is a number of cases that actually were aggregated, but the title case derives from an issue in the city of Topeka, Kansas, where Oliver Brown, who was a black man, was upset by the fact that his 8-year-old daughter, Linda, was required to attend an elementary school 21 blocks from her home, when there was another elementary school, Topeka Elementary, that was only 7 blocks from their home. But she was denied by that elementary school, and she was denied admission on the basis of one thing, her race. This other elementary school was an all-white school. So Thurgood Marshall, representing the Browns, said that this approach violates the principles of the 14th Amendment and Equal Protection Clause. And it goes to the United States Supreme Court. And on May 17, 1954, Chief Justice Earl Warren delivers the unanimous opinion of the United States Supreme Court. And he says the following. He says, the issue is simple. Does the 14th Amendment guarantee equal protection of the law or not? He says, the plaintiffs argue that segregated schools were not and could not be equal and were thus unconstitutional. Well, Warren said, we hold that in the field of public education, The doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. So for the first time, our legal system and the United States Supreme Courts strike down this idea of qualified legal discrimination, and we enter into a new era of legal equality. Legal equality. Now, when I say we entered that, it was not an easy transition. Many southern states in response to this were outraged, were demonstrating. We have governors who ran for governor on segregationist platforms, who were standing in front of the gates of their colleges, standing before their elementary schools, standing before their high schools, denying entrance to African American students in violation of the United States Supreme Court holding in Brown versus Board of Education. There were riots. There were attempts to impeach Warren because they said he's obviously a radical. Well, eventually the Supreme Court follows up with Brown versus Board of Education and passes and makes the decision of Brown versus Board of Education 2, which is a directive to state and local governments talking about how they had to conform to this holding. How they had to conform. And what they say in Brown versus Board of Education 2 is that the states and localities had to implement these decisions with all deliberate speed. All deliberate speed. So that they couldn't delay. Because some states were saying, all right, we'll comply with this. It'll take us about 50 years. And the Supreme Court said, no, you must desegregate with all deliberate speed. So they do. They finally comply. So the question for the civil rights movement becomes, okay, is this battle against racial disparities, is this battle of racial discrimination over? And the NAACP says no. That just because we now have legal equality as a result of Brown versus Board of Education, the struggle for civil rights is not over, and the objectives haven't really been achieved. So they asked, what were the major objectives of the civil rights movement? They said, Brown, all it did was guarantee equality of opportunity. It simply means you can't specifically discriminate based upon race. But when you looked at the impact after Brown versus Board, there were still significant differences in regard to income, poverty levels, unemployment rates, mortality, morbidity statistics, education levels, nutrition between African Americans and the white population. And given these disparities and the ability of discrimination to persist, the civil rights movement enters a new stage. It goes from just saying, okay, equality of opportunity is enough, to we need equality of outcome. That equal rights were not enough, did not result in equal living conditions. That these disparities were as apparent as before. So the call comes from equality of outcome and this notion of benign discrimination and the implementation of affirmative action policies. And that's the current era that we're in. What do we mean by affirmative action? Is this a good thing or is this a bad thing? What's affirmative action? Again, civil rights groups are saying that this is necessary. Why? Well, you can still discriminate as long as you don't use race, they said. So sure, say you're an employer and you don't want to hire African Americans. You can't have an ad saying African Americans need not apply. Maybe what you can do is have an interview process that's part of the hiring process, and all you can have to say is that all of the African American applicants did not interview well, and that would allow you to continue to have a segregated workforce. And what we were finding, especially in the South, that's exactly what was happening. So the civil rights group saying, see, it's not enough. Legal equality is not enough. We got to guarantee equality of outcome. And we can do this through affirmative action. So what's the meaning of affirmative action? Well, that's changed over time too. Affirmative action originally meant aggressive non-discrimination or a strong commitment to equality of opportunity for all, regardless of race or ethnicity. And President Kennedy in the 1960s was the first president to use this term when he said contractors will take affirmative action to ensure that applicants are employed without regard to their race or national origin. Now that approach didn't seem to produce any significant changes either. So this notion of affirmative action continues to evolve and had a new meaning. And if you look at your book in Jan, that says the new meaning was the giving of some form of special consideration to members of groups that have been traditionally, legally, and systematically discriminated against in the past. And special consideration can mean many things, from aggressive recruiting to remedial training, to remedial education, to special admissions programs, and even in some contexts, quotas, requiring that a specific percentage of jobs or school admissions be set aside for previously underrepresented groups. And again, affirmative action aimed to overcome the effects of past and present discrimination. And it was President Johnson in the early 60s who provides the rationale for this strategy. And here's what he says at a speech in regard to the issue of discrimination. He says, you don't wipe away the scars of centuries by simply claiming, now you are free to go where you want and do as you desire. We seek not just freedom, but real opportunity. We seek not just legal equality, but the affirmation of human ability. Not just equality as a theory, but equality as a fact, and equality as a result. So he calls for the implementation of affirmative action policies. And states and localities throughout the country comply. And it leads to a very famous affirmative action case. And that's the case of Bakke versus the Regents of the University of California. And this is in your book too. And this was a case that's decided by the United States Supreme Court in 1978. And it's decided by a very close margin, 5-4. So the facts of this case was that Alan Bakke was a 35-year-old white man, and he applied to Cal Davis Medical School and was denied admission twice. He did some research, and he found out that the medical school had 2 separate admissions programs. It had a special admission program that reserved 16 of the 100 entering spots for disadvantaged members of certain minority races. So when Bakke looks at the people who were admitted in that program, he found that his standardized medical scores and his GPA were higher than these students. So he sues the University of California, claiming he was denied equal protection of the law. Well, that's kind of ironic, because now you have a white person, a white male, saying that the 14th Amendment doesn't allow for discrimination. So the state trial court held that the medical school special admission program constituted a racial quota and therefore did violate Bakke's constitutional rights. The Supreme Court of California affirmed the trial court's holding. So it goes to the United States Supreme Court, and Justice Powell, on June of 1978, announced the Supreme Court decision. But it was badly split. It was badly split. 6 of the 9 justices wrote separate opinions. What was the bottom line? Well, Powell ordered Bakke had to be admitted, but he said that the university could adopt an admissions program where race or ethnic background is simply one element to be weighed fairly against other elements in the selection process. But it could not use set-aside programs or quotas for particular groups. It could just be one factor. So what we're saying here is that he couldn't use a quota, but you could use affirmative action as long as it was just one factor to be weighed fairly against others.